Very quickly, Kathleen Hambrick, many of you have heard her before. She's come to previous conferences, and you know how important her material is. So please give your full attention to this. We'd ask people not to be speaking to each other. If you have something you have to deal with, please take it outside the room so that we can all really focus in on this important topic. So Kathleen is an advocate against police entrapment. She has appeared on numerous media outlets and is a frequent guest on NARSOL's Registry Matters podcast. She currently lives in Indiana with her son, Jace. Kathleen, welcome. Thanks for joining us.
Hi, guys. I brought a little chair because I don't want to stand the whole time. So I'm Kathleen Hambrick, and I'll be presenting information that I've learned concerning police proactive stings to you all this afternoon. Righty. Hopefully I figure this out and this doesn't wobble off. Okay. So I'd like to start with a brief introduction of myself and tell you what happened to me and my son. I'll go briefly over some of the information I presented in 2020 concerning ICAC. I'll discuss things that I find to be general truths within these stings because they're they have a lot of commonality between them. We'll look at some specific pieces of information from our second trial. My son and I went through 2 trials. Okay, he went through it and I just tormented myself. And I'll also share what I learned from one of the jurors who was in our second trial. Wrapping up, I want to discuss recent changes, both good and bad, in regards to entrapment litigation. And I'd also like to discuss the niche of proactive stings within the NARSOL community. My journey started on a rainy Friday in February of 2017 when my son was charged with attempted rape of a child in the 2nd degree. We lived in Portland, Oregon at the time, and I didn't know anything about stings. I had never watched To Catch a Predator. I knew nothing about this stuff, and it was a complete shock, and I had no idea what was going on. But I had been working with police for over 20 years when this happened to me. And so if you had asked me on that day, this life-altering day, I would have never, ever suspected that police or the justice system in general would target and entice and lure and pressure innocent men into conversations manipulated to appear inappropriate with potentially criminal intent. Yet that's exactly what happened to my son, Jace, and has happened to tens of thousands of other unsuspecting men in innocent families. I grew up believing that cops were the good guys, and maybe they were, but Andy Griffith is dead. As we all know from the last decade of events, police today are trained and equipped to be lethal and self-serving, in contrast to the needs of the communities they are supposed to protect. As I researched what was happening to us and why, I tried a number of different ways to get out our story. I created a blog documenting my journey online so that if other people found themselves in the same situation, they could find some information. There was nothing out there when this first happened to me, and I scoured the web. I put a message out on a billboard in Washington State to try to warn people. That's what this is a picture of. I got that from 3 billboards in Ebbing, that movie. I created an animated video that depicted what was happening and put it on my blog. I met with a Washington State legislator, showed them the video and told them what was happening. I recorded a video through Florida Action Committee. I don't know if they're here, thank you very much. Through Florida Action Committee project that depicted our journey and explained why it was happening. I worked with a New York Times reporter who wrote an article about my son and others caught in the stings in Washington State. I co-created an advocacy group called CAGE, Citizens Against Government Entrapment, to pool information and efforts and to offer emotional support to other victims across the country. I appeared on the Dr. Phil show. I worked with the Washington State Sex Offender Policy Board to create a report for legislators advising a diversion program for those convicted in stings or depictions who had no prior convictions. I appeared on the Mike Morse podcast. Mike Morse is the lawyer for Chris Hansen. To repudiate misinformation vigilante guests were presenting. And I've presented at NARSOL, written for NARSOL, written for Florida Action Committee, been on NARSOL's podcast a number of times to discuss proactive stings and entrapment. As shown in my last presentation, proactive sex stings evolved from a perverse incentive loophole within our government's attempt to safeguard children from the internet. ICAC, Internet Crimes Against Children, was created in 1998. At that time, stings were reactive, an investigation of alleged misconduct reported to the police. But even then, there were concerns voiced about potential misconduct. In 2001, an ICAC report repudiated that police were manufacturing crimes through proactive stings. From the beginning of the ICAC task force, real children in immediate danger were set as the highest priority. The loophole was found in the least prioritized category, other children victimization, which encompasses proactive stings. Over the past 10 years, as adult sites and hookup sites have become more popular, ICAC has predominantly organized proactive stings on these platforms using bait and switch. Here's the codified funding formula for the 61 ICAC task forces across the country. The formula shows the number of investigative leads and successful prosecutions are part of the funding equation. Unfortunately, reactive cases involving real children are difficult and time-consuming to investigate and often do not result in successful prosecutions. Enter proactive stings. Quick to execute, easy to work many cases at a time, usually results in a successful conviction through a plea deal. Unfortunately, due to these lucrative factors, proactive stings have become the norm, leaving real children exposed and vulnerable. We're now going to move into what happened in my son's case and what I found to be true in these cases over the last 7 years. A little bit of housekeeping. I am not an attorney. Try that again. I am not an attorney. What I'm presenting today is based entirely on my circumstances, my personal opinions. And the second thing, as you might have noticed from our testing, is I have a number of slides that have video on it, and I sped them up because of time constraints, and our defense attorney talked really slow. So I've sped up the videos, but now the cop sounds like a chipmunk, but I'm okay with that. So, people reach out to me regularly asking if they should take a plea or go to trial, or if the plea deal they've been given is a good one. I found over the years in these proactive sting cases that there are 4 pieces of information you need to have on hand before you make any kind of decision. When you have these 4 answers, you're going to have a good idea if the plea deal is good or not, or if you have any chance at trial, which most people unfortunately don't. The first consideration is going to be your state or federal if you're charged federally. You have to know what your sentencing is for that state, for that crime that you're being charged with. You have to know if there's mandatory minimums in your state. You have to know if there's civil commitment in your state. You have to know if the sentencing is determinate or indeterminate. You have to know all these things. Your defense attorney should tell you all of this stuff. If he doesn't, you need to ask him because you can't make a decision without this. He should also be able to tell you not only what's the normal standard range, but what people in a similar situation have been getting in his state, your state, her state, who's ever. I'm going to show you Jace's sentencing grid to give you an idea of what it looks like. One thing to watch for is the offender score. Some prosecutors will try to split the charges so that they can up the offender score and then make it seem as if they're going to get more. They can get more sentencing if the offender score is higher than 0. In this case, Jace didn't have any criminal history, so it was obviously 0. But they might try to put in a number there and say, oh, well, these were 2 separate situations. No, they weren't. They were 1 crime. The standard for the state of Washington for attempted rape of a child is 5 to 7 years. There is a plus enhancements. For instance, if you brought a gun to the trap house, you would get an additional so many months. They total it up, and in the state of Washington, there is indeterminate sentences, which is similar to civil commitment in that when you finish serving your time, so you got 5 years, you serve your 5 years, you go in front of a board and they decide if you're releasable. If you're not, they hold you for 2 years. And then you go in front of the board and they decide if you're releasable. They can hold you up to life. So it's very similar to civil commitment in that regard, and you need to know if that applies in your state. The second thing that's very important consideration is your attorney. And I'm not trying to offend any attorneys in here, but what happens is you get charged. You race out and you get a lawyer. You need a lawyer, and you get a lawyer for sex offense charges. But this is an entrapment case. Those are not the same lawyers necessarily. So you have to know that the lawyer that you have is going to fight law enforcement, because there's no other way to win an entrapment case if you don't fight law enforcement. So you really need to make sure that's, in line with what your lawyer is willing to do. Some lawyers are not willing to fight law enforcement for their own reasons. They work in that community. They have to deal with the police all the time. They don't want to fight law enforcement. If you're not sure how your attorney feels about it, we actually got a deposition questionnaire from a defense attorney, I believe it was out of Florida. And we have some examples. My co-host here has some examples to put out if you guys want a copy of this, or you could reach out to me and I could email it to you. Anyways, if your attorney reads this and is uncomfortable with these questions, you do not want to go to trial for entrapment with that attorney. There are other defenses besides entrapment to a police proactive sting, but we haven't found any of them to gain any momentum other than entrapment. The third consideration is your personal situation. So I like to think of Jace's case was a perfect storm. Jace was 20 years old. While he had 2 jobs at the time and he immediately lost both of those, he didn't have any children. He didn't have a wife. He wasn't taking care of an elderly parent, not yet. And he lived at home and he had no obligations. So he was able to, being able to stay and live at home, I was able to afford his luxury of choosing what he wanted to do. Not everybody has that luxury. If you have a wife and family to feed and, you have obligations that he didn't have, you might have to decide to go with a plea deal because a trial takes years. So you have to gauge your own situation. 2 things to remember on that is that in some states, and once again you'd have to ask your defense attorney, in some states you have to, if you choose to take a plea deal, you have to go in front of the judge and agree with the charges as you take their deal. If you're not willing to do that, now my son said he would never go in front of the judge and say he did something he didn't do. Of course, he was well-fed and had a roof over his head. So that's a consideration. The other thing is there are also Alford pleas in some states, not all states, where you can take the deal and not accept responsibility or not admit guilt, however you want to put it. But again, you'd have to know if that was valid or an option in your own state. The fourth thing that you have to do is you have to give full disclosure, and you have to do forensic investigation on your full disclosure. And there's a lot of people that'll fight me on this, but let me explain. First off, get all of your discovery up front before you decide trial or plea, because if they don't have it all, then you need to know that, okay? So if the prosecutor tells you they can't get a piece of evidence, you need your lawyer to go in front of the judge and compel it. If they still can't get it, they should be requesting a dismissal or asking for sanctions for spoilage of evidence. You are entitled to your full discovery. In April of 2024, out of Bakersfield, California, a man was acquitted of charges in a proactive sting trial. The report in the newspaper said the sheriff's investigator in Bakersfield, California, failed to preserve exculpatory evidence and made statements contradicted by others at trial. That man went free. After you've done your complete discovery, you have to do a forensic investigation. And this is why. And the first question people are going to say, well, how much does that cost? Okay, that costs $7 to $10, and it's typically not included in attorney's fees. Most attorneys don't have a forensic investigator on staff. You can get a third party to do this work. Some of them do. It's getting more common as things get more complex. So then I'll hear from people, some of them will say, well, my attorney's going to look through all of this stuff himself. He knows what he's looking for. And my answer to that is, your attorney is not an IT professional. I'm sorry. There are simple manipulations that he could find if he'd been doing some of these cases and he knew what to look for. There are simple manipulations that he could find, and let me show you one. This was in Jace's. You're not going to be able to read it, so I'm going to explain what's going on. But this is Jace's text, and it starts out with the undercover saying she's playing Alien Isolation, which is a video game based off of the movie Aliens. Pretty scary stuff. Yeah, right. Everybody's like, ah. Okay. So then Jace goes, forget sex. I want to come watch. Okay, that's my 20-year-old son, right? And then the undercover says, I'm a 20-year-old, tired from work, blah, 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 blah. And then the undercover says, I'm 13. Okay, so clearly that's not really what was said. What we figured out was that the undercover said something else, not I'm a 20-year-old white guy, that was my son. She said something else, and then there's a header for Jace's comment of, I'm a 20-year-old white guy. These two pieces got cut out for whatever reason. I don't know, and it doesn't even really matter why. The fact that they submitted this as a true and accurate depiction of what happened, and you can poke a hole in that, is evidence tampering. It is, for whatever reason. So you can use that. A good lawyer should be able to find that. I will tell you that we went through the first trial and our lawyer didn't even see it. Didn't use it, didn't acknowledge it, didn't know about it. But in addition to that, there are logs, caches, and data integrity that we can't see. I am a computer programmer and I don't know where to look for this stuff, okay? It takes an IT professional to get to these levels. And I'm going to go over some slides showing you some examples because I did speak with a forensic investigator and he handed me some information. So what happens is when they first confiscate your devices and they seize your devices, they're supposed to put it in airplane mode and not attach it to any thumb drives or the internet or anything because they're trying to preserve the data as it was the moment they confiscated it, right? And then they run an extraction file that they can do reports off of to get information off of, and I see heads shaking, so you guys have been through this. So this one is, and you can't see me pointing, but it's an iPhone 8, and you can see that it's called a file system extraction. It was created on 12/7. The bad part here is on this extraction file, it was modified on 12/23. Evidence tampering. Right there. Your attorney is not going to find that. The next one talks about in the log. So anytime something happens on a computer, it's logged as to what somebody does. I know you guys don't necessarily know that, but it's true. Within this file, within this extraction file, there was inserted data. The forensic investigator can find it. That is evidence tampering. This one, they sent and received a message. Evidence tampering. This is the most egregious that I saw. This agent connects to the internet, goes onto a message board, searches for child porn, and downloads it onto this person's system. This is in a real case. And I'm getting chills. I don't know what you guys are getting. I'm getting chills. And then, so there's something called a hot loader where you can put an application on that'll change little bits of data throughout the files. Like without having to rerun something, you can just kind of poke in and change. So you can use that to change like the dates that a file was created or a date it was modified and all these things. And some cops are smart enough to know about this because, they got burned. And they're right behind us. They're trying to catch up. Okay, what did they catch me on? Now I've got to fix that, and I've got to fix that. This person, I happen to know that this person's device was seized on 4/22 because it's Jace's birthday, and so it sticks in my head. I was busy that day. And it was seized about 6 o'clock in the morning. So you can see that the files, these pornography files, were created on 4/17, which is 5 days before, right? So the cop did do that right. And the modified date matches it, 4/17. So the cop did it right. But there's a third timestamp, which is called accessed. So you have created, accessed, modified. They should all be in a row. chronologically, the access date is 4/22, right after the thing was seized. You think? That would be evidence tampering. All of this is information that you can use. So before you make a decision, plea deal or trial in a proactive sex sting case, you need those 4 pieces of information: your state, your situation, the lawyer you have, and your complete forensically investigated discovery. Then you will have a clue which way to go. You get a plea deal, you'll know if it's good or bad. You want to go to trial and they didn't find any tampering of evidence, you know that you're fighting an uphill battle. Okay? It's just one last thing. In my opinion, do not ever accept a bench trial with one of these stings. In these stings, you are fighting the government. Do not let the government decide if the government was right or wrong. Okay? You need a jury. That's what I'm saying. Okay, we're going to move on. Oh, one last thing. There is a law firm that is here in Atlanta called Brody, and they deal almost exclusively with sting cases. They're very expensive. They have on-staff forensic investigators, guaranteed. And they have on their website page of their wins, and you can see on here, if you were able to read it, which you probably can't, there's not guilty cases, there's dismissed for, there's dismissals, and there's reduced charges to misdemeanors. And if you drill down into these on their webpage, you'll see that a lot of them have to do with, you know, things not lining up, and that you know that the forensic investigator got in there and said, hello, dismissed. So that's a good place to go for information. Okay, we're going to move into voir dire. I'm going to take some water. There's a lot to say. And voir dire is really the start of the trial. It's where the judge, prosecution, and defense all get to have open conversations and ask questions of the jury pool. And what they're going to do is release people for cause. And cause can be anything from a hardship to a bias. And so as far as hardships go, it could be that if you don't work this week and you're in the jury, then you can't pay your rent, or your kids go hungry. That's a hardship. Or you can't sit on the bench for a week because you have whatever, sciatica. That's a hardship. But there's also biases. Say something happened to you when you were a child, you hear what this is about, and you just wig out, you can't do it, right? Emotional trauma. All those reasons are valid reasons to be removed from the jury pool. And in Jace's case, there was 45 people within the jury pool, and they make them larger for any kind of sex offense charge because you lose a lot to bias. So the really interesting thing that the prosecutor did was they came out and stated no children were harmed in this case. There were no children involved in this case. And I think that was really smart because we didn't have mass exodus of people saying, I can't possibly sit on this jury because I just have too much of an emotional baggage about that. So
Quick question. The government said that there were no children harmed?
the prosecutor did to the jury pool, yes. Yes. But then the prosecutor came out talking about online dating. And I thought it was really important that our defense attorney didn't come out talking about online dating. They came out with the first words about entrapment. This is where the defense starts, in voir dire, because you can have open conversations. And, you know, nowhere else in the entire trial can you have an open conversation with your people that are going to be on your jury. So he comes out and starts talking about what is entrapment, who knows what entrapment is, where are the lines, what happens if they go over the line, you know, what are the laws regarding this, does anybody know? And there's all these conversations start going about entrapment, and it was really very ingenious. And that was really well done. So they also talked about gaming, which a lot of people are gamers now. I don't know if you guys know that. I'm not a gamer, but my son is a gamer. And the ad that he answered had to do with gaming. He didn't answer an ad about anything sexual or anything like that. It was, I'm a gamer. Okay, well, he's like, yeah, that's me. Anyway, the other thing, and I did want to explain that there are preemptive challenges. So in addition to being for cause, you have a bias or a hardship. There's also preemptive challenges, and there's a set number of those that any attorney can do, and you can just say, I don't like number 10, and so but you can only say that about so many people. So it's really important to bring out all of the biases within the voir dire so that they know who to say, I don't want you, I don't want you, I don't want you. But the rest of you are good. So anyways, those are preemptive. And in Jace's case, they had a number of those, obviously, because there's a lot of biases. So they talked about gaming, they talked about Craigslist, scamming, catfishing, all the things you'd think of. The defense attorney brought up information about, do you think that if a police officer is on the stand giving testimony that it holds more weight than the defendant or than anybody else? And that's another bias, is that we tend to believe what the police are saying for some reason. And that when the attorney is talking, that he's not giving evidence, he is trying to persuade people to go along with what he wants them to believe. And so that's not evidence. But there are plenty of biases, and this next clip is really hard to understand, so I'm going to kind of preface it with what's happening. This is in voir dire where they've asked for biases, and this one lady raises her hand, and she starts verbally attacking my son who's sitting at the defendant table. And the really funny thing about this is I am sitting right behind her.
Yes, ma'am.
I don't feel that I can be unbiased.
Okay, you don't think it can be unbiased? Okay, move it on.
I don't feel like that, okay, when do you decide, did you quit once, did you quit twice? You know, how much did you carry on with this person? What is okay, what is not okay? You know, you quit. There's a reason you're sitting there. You quit.
Okay. So,
You had intent.
so you're assuming certain things.
Yes, I am assuming that.
Okay, and, but like I said, you haven't heard anything yet, and the judge hasn't told you what the law is regarding this case. But you just feel that from your own, I guess, personal
Yeah.
beliefs or feelings that this is not a fit for you. Okay, and that's perfectly fine. Thank you for letting us know.
So, yeah, talk about a bias. So the nice thing is that actually the prosecuting attorney cut her for cause, which was good. So next we're going to move into our defense attorney started talking about the ops plan and the mission plan, and bringing up how the mission plan did not match what the police were actually doing, the tactics they were using. It didn't jive, and he brought it out in them, and I will show you that clip in a minute. Then he also brought out how there were 60 to 70 police officers used at the trap house in order to entice these men in. And because of, they only have like 4 or 5 days in order to run a sting, but they want as many as arrests as possible. And so it gets to be almost this frenzied game kind of, I bet you I can get more guys than you can get, you know, and it really starts to get off kilter from what it's supposed to be, that is about saving children from potential harm. And that's a good ring. And and he also brought out that from the detectives that they were supposed to focus on persons with a predisposition or a prior history of preying on children. That was part of the mission statement. But even after they qualify that this does not apply to the person they're talking to, he shows how they continue to talk to that person, and so it's clearly not true.
As stated in the operational safety plan, it will focus on subjects that have a history with sexually abusing children, have stated they sexually exploit children, and recovering children that are being sexually exploited. Correct?
I don't recall. It certainly could have been in that operational plan, sir.
Now, in this case, to your knowledge, there was no evidence that indicated that Mr. Hambrick had any history with sexually abusing children, correct?
No, my contact with Mr. Hambrick was strictly via the emails that we've gone over and the text messages that we've gone over.
There was nothing that during your contact with him that would have given an indication that he had previously sexually exploited children, correct?
Well, again, I'd refer you to the emails and the text messages we just went over, sir, and I didn't have any other interaction with him other than that.
And then the other thing, recovering children that are being sexually exploited, which that's not even applicable to this case, correct?
That's not no, not in this particular case, no.
Nope, nothing. Next, our attorney went through the prosecutor's points one by one, showing misleading information and subtle manipulation. Examples of purposely misleading information can be found in riddles. For instance, how many letters are in the alphabet? Okay, the answer they're looking for is 11, 3 in the word the and 8 in the word alphabet. In the alphabet are 11 letters, purposely misleading information. Another one is a bus driver goes the wrong way down a one-way street. He passes the cops, but they don't stop him. Why? No, it's because he's walking, not driving. But misleading information. You assume the bus driver is driving, but he's not. It works in riddles, and it works in stings. Just like in the riddles, police are trying to lead their target to a certain conclusion. Conclusions that law enforcement will take the stand or speak to the media stating that the target believed to be true. But only the defendant themselves actually knows what they thought. And in our second trial, it was very important to Jace that his perspective of multiple statements be shown. When I first got to speak to Jace after he was arrested in February of 2017, he told me the reasons he believed he was speaking with an adult. But we feel that Attorney Lane did a great job of explaining what was said and how each statement could have been taken. I also feel a bit guilty about having a good mother, and I know that's a weird thing to say, but by raising my son in a loving, protected home, there were things said that he thought proved that this person was lying. For instance, in the text, in the chatter, the undercover states that their mother was going out with her boyfriend and wouldn't be back home until the next morning, while she claims she's 13. My son said, what mother is going to leave their child home alone till the next morning when they're 13? He thought for sure that meant she was lying. Now, as adults, we understand that there are neglective people out there, but as a 20-year-old sheltered young man, he knew it was an adult. Was he wrong? No, but he wasn't right for the right reasons. So, I'm going to go through these one at a time. The first one is that one of the biggest factors in not believing the undercover was 13 was that Jace was on an adult website, in fact, a sexually charged adult website, where he felt no child was ever going to go. When pressed, the undercover officer told the jury that his ICAC training instructor had told him to place the ads under no strings attached, casual encounters, within Craigslist personals. That is subtle manipulation.
Now, in your previous testimony, you indicated that you're a gamer, correct?
Yes, sir, to some degree.
And that you based this persona because of your familiarity with gaming and games? Is that fair to say?
Yes.
Okay. And you indicated that Alien Isolation was a game that you actually played, correct?
Yes,
Okay.
I was at that time.
All right. And how old were you at that time when you were playing Alien Isolation?
Over 45?
All right. Why not use a children's game in your answers, such as, I don't know, SpongeBob or something that would indicate clearly that somebody's 13?
Sure. So it's important to go ahead and associate yourself with something that you're intimately familiar with. So for instance, if I suggested a game like Super Mario Kart, right? The problem is they'd say, who's your favorite Super Mario Kart character? And I'd be like, I don't know because I don't play Super Mario Kart. I wouldn't be able to have a extended conversation about it. So what I try to do is either I choose something like I educate myself about the game, or it's easier just to use a game that I'm actually playing so that I can get over that proof of life type of thing. So in other words, if someone had asked me what game you playing, and I was said I'm playing Alien Isolation, and if they had asked me a specific thing about that game, I'd be able to answer it. And that's why I chose that title right there.
Would it not send a clear message to someone if you indicated a game that was rated for a little kid?
Again, at 13, my experience has been that 13-year-olds do play more mature rated games, and they do play the more age-appropriate games like Super Mario Kart. But again, I think if I can reiterate my previous point, that I needed to go ahead and stick with a game that I was familiar with in case someone started asking me questions about it. I had to be prepared to have a conversation about it.
But apparently, 50-year-olds also play Alien Isolation, correct?
45 or older, yes, sir.
Okay, excuse me.
Yes, sir.
Now 50, back then 45.
Yes, sir. Yes, sir.
And Alien Isolation is basically rated for mature 17 and over.
I believe that's correct, yes, sir.
You can see why I don't care if he sounds like a chipmunk.
So Mr. Hambrick's initial response was, and then the XD, that means funny or laughing, correct?
Oh, like a grinning emoji, I guess. I think I'd let it speak for itself.
Okay. Any questions? Why did you post an ad in Craigslist if you're 13, correct?
Yes, sir.
You mean 23? Question mark, correct?
Yes, sir.
And then your response is, sorry, I like college guys, laughing emoji back.
No, kind of like a stick in the tongue out, like a kind of emoji.
Okay. But you didn't specifically answer that question, correct?
No, I made a statement, I think I made a statement earlier about that message, that the reason why I chose that, I like college guys, was I was trying to imply that I myself was not of college age.
But it still doesn't establish, it's still rather ambiguous. The response, it doesn't specifically address why you're in a section for over 18 or over if you're 13, supposedly 13.
Yeah, it was not a direct answer to the question.
Subtle manipulation.
A picture is sent of somebody in their mid-20s.
Yes, sir.
And at this point, they've indicated one time that they're 13.
Yes, sir.
Okay. But the visual message is that it's an adult, correct?
Well, the photo, like I testified earlier, the photo is taken in order to appear as a post-pubescent minor. So we do the best we can to try and take it with lighting so that it appears consistent with them.
Well, would it be fair to say, or would you agree that different people that look at that photo are going to have different opinions of what the age might be?
Well, I can't speculate about anyone else's opinion, but I look at that photo and I guess I would let the photo speak for itself. That might be the best thing, sir.
Would it be fair to say that you see what you want to see, correct?
No, sir. Because and if I can elaborate, I've taken photos before with UC decoys, and I go, oh no, that's awful, that's terrible. No, we can't use that. So I don't. No, sir.
Okay. But also at this point in sending a picture, you do have the option, or did have the option, to use the picture of an actual 13-year-old, correct?
Well, like I said before, we have to use what we have available to us. So we had, basically there were two options with a lesser third. So we had the option of either using a younger police employee that could pass for a post-pubescent minor, or we had to use photos of a police employee from that person's past. And we can use photos of police employees and use age-altering software. At that time, we didn't see a lot of that. There's been advances since then, but at that time, we were basically looking at the first two options, either using younger photos of a police employee or taking photos of an existing police employee and trying to take the photos in a manner where it appeared consistent with a minor. We decided, upon looking at that that was the best option to do that. I don't know if you want me to elaborate on that.
Well, was it the best option, or that's what you thought was available? Okay, we got a 25, 24, 25-year-old that we got to use.
Sure. It's the best option because, again, we often have people ask us for proof of life. I've had an individual who said, pull up a sign with my name on it saying hello. And so if we have a decoy that's there and we're not using pictures from the past, we can quickly kind of take those photos and provide those proof of life photos in real time to the person that we're chatting with. If we had used photographs of, say, Officer Janish when she was 12 or 13 years old, everything, her appearance would look radically different from when she was 12 or 13 to currently. So the best opportunity for us in this case was to use an actual decoy, in this case Officer Janish, and try and take pictures of her in a manner that appeared consistent with a minor female.
12 or 13 years old, that's 6th or 7th grade, correct?
6th to 7th grade, yes, sir.
Okay. So you're looking at a 24 to 25-year-old. It's a big difference between a 6th to 7th grader and somebody that's 24 to 25, would you say?
Yes.
Purposely misleading information.
And at the top, another incoming message from Mr. Hambrick question, you live alone, correct?
Yes, sir.
Okay. Can a 13-year-old live alone?
They shouldn't.
Is it even legal?
No, sir. It is not.
Would that have given you an indication that Mr. Hambrick still believes he's talking to not somebody that's 13?
It's indicative, yes, sir.
Okay. And you could have cut off the conversation there because it appears that he's not looking for a 13-year-old, correct?
I could have done that.
And your response is, I live with my nosy-ass mom. And I believe you testified earlier that was trying to show an indication that it was somebody that's young.
Yes.
And that lots of people nowadays, 17 to 25 and even older, live with their mom or dad. Or
It's
their
possible.
parents.
Yes, sir. There are people that do.
It's possible, but it's quite common now, correct?
I haven't taken a demographic or anything, but I understand there are people adults who do live with their parents.
Okay. So again, that's something that's vague. would not specifically identify somebody as a 13-year-old, correct?
On its standing on its own, no, sir.
No, sir.
And then your response is, who says I'm a virgin, laugh out loud, correct?
Yes.
So about halfway down, talk about getting condoms, and your response, cool, because I don't got any, kind of smiley face, thumb sticking out or whatever, correct?
Yes, sir.
Okay. And earlier you testified that you put that in there as a signal to show that the person's not sexually active, correct?
Yes.
Okay. But just previously, you had sent a message indicating that she's not a virgin, so that kind of contradicts itself, correct?
Yes, I can see that it would be contradictory.
Yeah, all purposely misleading information, subtle manipulation. So I hear from a lot of people that their state does not allow the entrapment defense. I've heard it from people out of Florida, and in fact, in the state of Washington, our first attorney told us that we couldn't use entrapment. And it's not entirely true. I found out that you could use entrapment, but the bar is set really, really high in order to get the entrapment instruction to the jury. And this happened through precedent. The rules had changed so that the judges themselves listen to the evidence and personally decide if entrapment is probable. And then they choose to allow or disallow the instruction to the jury. So basically, they're deciding the case. There are 3 factors involved in the entrapment defense. The first is to show that the crime originated in the minds of law enforcement, and that's a given in all of these sting situations. The second is to show the defendant had no predisposition to commit the crime, which is you can show they had no criminal history and they had no depictions on their devices. Those kinds of things are something that would allude to such a statement. And then you have to show that law enforcement did more than merely afford the opportunity to commit the crime, but entice the target in some way. And this is called a plus factor. So in order to get the entrapment instruction, you have to have a plus factor. And that is where subtle enticement by law enforcement is ingenious in creating sting convictions. Douglas Arbogast argued in the state of Washington for the entrapment instruction and was denied. He used that information in his appeal, and the appeal judges found there were valid reasons to argue entrapment. So they overturned his conviction, and his case went back to the lower courts. Now, in the state of Washington, all that's required is the showing of prima facie, which means there is some evidence of the 3 required entrapment pieces. The judge is no longer allowed to personally weigh the evidence before giving the instruction to the jury. This appropriately re-lowered the bar in the state of Washington so that people could start using entrapment again, and this was in March of 2023. And that is what allowed Jace to use the entrapment without the need to convince the judge before convincing the jury that he was entrapped.
And basically, they talk in detail about the lively factors, and one of the things that's discussed is the subtle inducement. And this case clearly has at least subtle inducement. You know, it's not a situation that we have here where it's just the person states that they're 13. You know, they're put an ad in a already sexually charged section of Craigslist indicating by the terms of use that they're an adult, which is clearly a misrepresentation. It would be a reader of the ad to believe that since it's in that section, the person that they're communicating with is at least 18 years old. And basically, when my client first responds, clearly that, you know, he's there looking for sex because that's what that section of Craigslist is for, that he believes that he's talking to an adult, not a 13-year-old. So the conversation goes on a bit until the state introduces the age, but even by the detective's own admission, the other facts, or the other items that he's throwing into the conversation, he clearly indicated that he was intentionally being ambiguous. So that keeps the conversation going. The use of in the ad as well as far as a game that's rated for adults, and Detective Gibbons even testified that since he's a gamer and he's familiar with this sort of stuff, that he used Alien Isolation because it's a game that at the time of the sting he was 45 years old that he played himself. So another ambiguous fact of introducing that game instead of a child's game to lead somebody to believe that they're communicating with somebody that's at least 18 or older, when it got to the point where a photograph was introduced. are said. Again, it's a subtle manipulation, at least, by sending a photograph of somebody who's in their mid-20s. As the conversation progresses, because at the beginning it was quite clear that my client was not there looking for a kid, because once the age was initially introduced, his response was, "What do you mean?" We're like, "Well, why are you here? Because you mean 23. Thought it was maybe a typo or something."
So at this point, some people might be questioning, well, why do you want the entrapment instruction given to the jury? Without the entrapment instruction, the jury is allowed only a small amount of doubt as to the defendant's guilt. With the entrapment defense, the jury only needs to believe it is more likely than not that the police entrapped him. The onus is flipped from the defendant to the police, thus giving the defendant approximately 50-50 chance of being found not guilty due to entrapment. It is clearly advantageous to use the entrapment defense in these cases.
For a affirmative defense, defendant has to make a prima facie showing of some evidence in support of the defense. So prima facie is a pretty low level. I mean, basically there has to be some evidence out there. I think Abogast goes on and says that state, or rather the court can't weigh the evidence. It just has to look and see if there's some evidence. So then second, I think as Mr. Bruce indicated, defendant has to present some evidence of inducement and predisposition. In talking about inducement, the court indicated that inducement may be based on persuasion, fraudulent representation, threats, coercion, harassment, promises of reward, and then pleas based on need, sympathy, and friendship. I think as Mr. Vu indicates, the question about inducement, basically asks whether the police went beyond simply providing the defendant with an opportunity to commit the crime. So here, I agree there is language in Abogast that inducement's not merely government presentation of an opportunity. There has to be an opportunity plus something else. And so in Abogast, what they seem to grasp onto was this idea that that while the undercover agent in Abogast was offering up her children to the defendant, she also indicated that there would be the possibility of a sexual relationship with her, with an adult there. And so that seems to be what Abogast, the court in Abogast, latched onto. So the problem I think I have here is that, I think we start back with the concept that the defendant is entitled, or both parties are entitled to any instructions which accurately state the law and allow them to argue their theory of the case. So the defense here clearly wants to argue entrapment. They've been indicating that since, I think, opening statement. I think the problem I run into, Mr. Vu, is I tend to agree in this case we don't have the sort of inducement that was here in Abogast. My concern, though, is the way that they stated this is that it has to be opportunity plus something else. And of course, they go in and they talk about such as excessive pressure. My concern is here we have some of these elements that the defense has identified, that the ad was in an 18 or above, area of Craigslist. I think a reasonable argument is, well, sub-18-year-old individuals put ads on there all the time. I think actually Detective Gibbons, I think, referenced that. But there's some other factors here, too. I think there's that. I think the adult game issue, the photograph of the detective, here being in her mid-20s, that's an argument to be made. But my concern really is that I think it's probably reversible error if I, deny the defendant the instruction and then the court finds something else. And I'm a little concerned that they left the door open to, candidly, a broad range of other evidence, that they would, look at or could look at in a particular situation and could decide that that was enough. I mean, their language is pretty harsh, but then they turn around and, they relied on, this assertion or this statement by the detective in Abogast that there might be the opportunity or an adult sexual relationship, in addition to that with the children. So I'm a little concerned about that. I'm going to grant the request to give the instruction. I know it's a close call, and I know that reading clearly the Abogast, there's a strong argument to be made that the defense hasn't made that burden. But I think they still, once the instruction is given, then they still have the burden to prove the defense by preponderance of the evidence. So I'm relatively comfortable that this gives them an opportunity to argue their theory of the case, but they still have to carry that burden to prove up the defense. I think I'm on much shakier ground if I deny them the opportunity to make that argument or deny them the opportunity to have that instruction in the package.
The thing the judge misses, in my opinion, is that the incentive the judge is trying to find, the plus factor, is the chance of sex with a consenting adult, which is why the person was on that website in the first place, okay? But for some reason, they don't see that. The incentive is hidden in plain sight. It is fundamentally unfair to allow a jury to convict without instructing it on the law relevant to a plausive entrapment theory that was fairly raised at trial. This was in a appeals decision to reverse a conviction for entrapment. After the trial was over, one of the jurors reached out to me personally and wanted to discuss what had happened in the case and give their opinions of it. Well, the first thing he said was that when they go back for deliberations, they take a vote right away, and that it was split almost perfectly down the middle between men and women. All the men said he was not guilty, and all the women said he was guilty. And so his assessment of this is that you should always try to get more men on a jury that you're doing for a proactive sting. That's what he told me. So additionally, both the prosecutor and one of the detectives during their testimony said that Jace went to the door when he got there and knocked on the door for the woman. But in the closing statements, our defense attorney showed a videotape that clearly shows that when my son arrived, he stayed way back from the door and texted the woman to come out to make sure that it was in fact a woman, and it was in fact a woman. But this put a good doubt in the jury's mind. It additionally put a bad view of the prosecution for having gotten that wrong or trying to pull that over. But mostly this juror said, and I'm kind of quoting here, in order to get convictions, the cops need better bait. And I think that was pretty accurate. So I am going to tell you that a little bit about recent rulings in academic, and I'm going to speed this up to try to finish this out. But there's been some progress. It's been slow progress in entrapment litigation. 3 different districts, Puerto Rico, Illinois, and Washington State, which are all different districts, have all reversed convictions through appeals where entrapment was not allowed as a defense. As I mentioned, and you heard from the judge in Washington State, Arbogast afforded Jace the entrapment instruction. Sadly, since then, since Jace's case, 3 others have been denied the entrapment instruction. We're hoping that the appeals court will hold up their precedent. The appeal decision, this is very important, the appeal decision out of Puerto Rico also discussed how one's eagerness after the crime has been presented to the target by law enforcement is not sufficient gauge of predisposition. Many times when I'm arguing entrapment with people, they'll say, just read the texts. You know, you'll know he's guilty. He showed up, he's guilty. Okay, but that's exactly what entrapment excludes. Predisposition is one's actions and leanings toward a given crime before first contact with law enforcement. In these cases, before first contact in law enforcement, this person was on an adult site looking for adult companionship. Okay? So there's a line in the sand concerning predisposition. At the moment in time where law enforcement starts contact with this person, do they have verifiable evidence that the target already has interest in this particular crime? If not, that's entrapment. So there's a bunch of academic studies. I'm not going to go down through them. We do have a printout if you are interested in the study information. These are all within the last 5 to 7 years. There's not a lot, but there is some happening, and we're hoping more will come along. These recent rulings and academic studies are the lifeline to change in all litigation. We all need to continue to be vocal. In Jace's second trial, 2 people within the jury pool said they had heard of his case. That's only because we've spoken out. We have to continue to do that. It's slow, but our voices are being heard. As to the outcome of Jace's second trial, after 1 hour of deliberation, the jury had all agreed that Jace was entrapped. Yet they continued to deliberate because some of the jury believed Jace was not guilty even without the entrapment clause. I'd like to reiterate that being allowed the entrapment instruction is the goal in these cases. Even if the jury doesn't use entrapment, the laws and concepts behind entrapment are foundational to a victory. After another 5 hours, 6 total hours of deliberation, the jury declared Jace was not guilty of all charges. We were able to get them over the 50% all the way up to the 90%. Not guilty. In the words of the New York Times Pulitzer Prize winning reporter Mike Weinrip, who did the report on this back in 2020, Jace had done the impossible. I'm not quite done. One more small section, sorry. Oh, thank you. Well, thank you. No. So I wanted to go over really briefly, and I'm hoping anyway. Our entrapment and the proactive stings are a niche in NARSOL. We're not the mainstream, but we are all here as a group So within the NARSOL community, we advocate for people. Some of our people have made a mistake. Some are afflicted with an attraction to minors. Some are accused of inappropriate behavior as retribution, like in a divorce or a custody battle. Some of our people have been persecuted for homosexuality or legal kinks. Some of us were entrapped by police. I feel this difference is important to point out. I see these three categories among persons required to register: those who have had an actual victim, those persecuted for their sexuality, and those maligned for ulterior motives. While this is a wide array of needs, we welcome them all. They are all persons deserving of dignity, respect, and second chances, and they all deserve to be heard. But there is one area where the needs of the persons within our community are especially contradictory. And that area is therapy and mental health. Persons forced to register who have had a victim have to deal with the guilt of having hurt another person. They may need help with topics like empathy, consequences, or self-control. Persons forced to register who were persecuted for alternative lifestyles deal with feelings of not being accepted for who they are. And persons forced to register from police proactive stings, as well as other ulterior motives, as I've mentioned, have to deal with feelings of betrayal, false accusations, defamation, and gaslighting. The therapy for these vastly different scenarios can be mutually exclusive, yet they all get the same therapy, that for sex offenders. While the mandated therapy may help some people, it unquestionably harms others. Insult to injury, it is often required within these mandated therapies for patients to vocalize specific criminal thought and intent in order not to be deemed a denier, potentially being kicked out of a required therapy program, and in some cases creating a parole violation. All this while completely ignoring the person's actual mental health needs. I hold little hope that the lack of customized, appropriate, and truly helpful therapy will change for the better anytime soon. But I also don't want to recreate amongst ourselves an opinion that I personally see as the largest issue with the registry, the myth that people forced to register are all the same. We are not all the same. We are individuals who choose to unite against the registry and irrational laws. Let us not gloss over individual needs, but rather endeavor to help each other through knowledge, understanding, and support. In conclusion, I hope you have gained some knowledge into stings and what worked in my son's case, and we're excited to see recent favorable rulings. We all still need to keep speaking out because the more often we do, the less likely stings will continue. Thank you. Any questions?
Question here,
Yeah.
this side. Recently, NPR had a broadcast on vigilante stings and entrapments. I went online and I looked at it. I'd never heard of such a thing, but there's all sorts of things. And basically, from what I can see, in some cases, these vigilante groups, the police show up and they arrest these individuals.
Yes.
In other cases, the people are arrested that actually, are being stung.
Yes.
And in that situation, I wouldn't see, I don't see it being processed once they go to courts, but the person still has a stigma of being arrested. And also, like in a month ago, they had a situation in Michigan, and these individuals brought them to a catch a predator situation, and then they made them eat food and drink a bottle of hot sauce. And they told them that it's online, and they told them that this is what they were not going to report them, but this was the punishment involved. So that's my first question, if you've heard of these. And second question, and I had a conversation with Lisa here, what happens if a situation is entrapped and an individual happen to have some type of challenge where he or she is autistic or has a mental processing challenge? Is that taken into consideration? So thank you.
Yeah, you're welcome. So I did mention on there that I was on the Mike Moore show because they were having a lot of vigilantes on there saying how, we had caught this person and we did this, that, or the other, and they're all full of shit in my book. And so I got on there and tried to set the record straight. So yes, I do know that happens quite often, unfortunately. Why it happens is because those people get subscriptions, so they make money by trying to, yes, it's a money game. Everything's a money game. That's why the police are doing the stings in the first place, guys, come on. And your second point was, I'm sorry, I forget. Oh, you were asking about. Yes, so there are a lot of people with, okay, so my son has ADHD. He misses a lot of clues. A lot of cognitively deficient people are caught in these. A lot of people on the spectrum, which I mentioned in the first half of this, not this one. It is really high because they don't catch the clues, the signals that the police are pretending are supposed to let you know it's really a minor. But it's a huge number that get caught in this. And no, there was a man that was caught, and 8 months later, they finally dropped the charges because he was mentally deficient. This guy had low, like, imbecile rating on the scale, and they were still prosecuting him. They do not care. They do not care. It's all about ratings, numbers of arrests and prosecutions. Yes?
Hi, can you hear me? All right.
Yeah.
First of all, I got to say,
There's a
what
map.
a trip.
Yeah, tell me about it. It's been a journey, all right.
So I have two questions. My first one is, can police be prosecuted for impersonation in cases like this? And
Legally or in reality? And there's a gnat that loves me.
let's go in reality.
No. Legally, yes. In reality, no. So they're breaking the terms of usage when they go onto these sites by pretending to be somebody else. They don't clear these things with that site. They don't have permission to be on there pretending to be somebody else. And if you go on the internet and you pretend to be somebody else, that is illegal, impersonating somebody. So yes, they should be prosecuted. No, nobody's going to prosecute them.
Interesting. Yeah, and I was hearing somebody say qualified immunity. That's part of the reason why I'm against immunity. My second question, I forgot what it was now, give me a second.
Good, because I'm glad, because I can't remember it either.
So you gave the example of a predisposition of a previous conviction.
Yeah.
Doesn't that violate the doctrine of innocent until proven guilty?
I'm sorry, what country do you live in? Yes,
that's-
of course it does, but you're asking for a special defense, an affirmative defense, and that is one of the three things that you have to prove. You don't have to use that to prove that you didn't have a predisposition, but if you already had a sexual offense charge on you or conviction, you're going to have a hard time getting over the threshold.
Okay, thank you.
In the case where the police downloaded the porn onto
Lovely,
that,
right?
what keeps them from being prosecuted for possession or distribution once that comes out?
Well, so the really funny thing about that whole thing is that the investigator, the forensic investigator, was going to testify, and they threatened him and said they were going to charge him with CP if he did. Now, the rules just don't seem to apply to these men, and we have to change that, but there is nothing that would keep them from being charged. Hello.
There we go. I think it's on now. Great presentation. I feel like, I know you said you're not an attorney, but I feel like I should
So
get
not.
CLE credit for that, because I feel like there's a lot
I don't even know what that is, so,
of continuing legal education.
Oh,
It was
gotcha.
very informative.
good.
One question I wanted to ask was, you put the statute up that showed the, I guess, the funding mix that ICAC task forces get. Do you have any additional information on how those factors are weighted in terms of funding that these task forces receive? Like, are any of those bullet points weighted more heavily
Yeah,
than
they won't
others?
tell you. I've tried very hard. I even said, to the director, and I forget who, it was Gersh, I don't know who this is, but his name was Gersh at the time, he was the director of the DOJ, and I said, how is it that you're putting this, perverse incentive out there? He's like, what are you talking about? I'm like, look, it says number of investigations and successful prosecutions. It doesn't say number of children saved. Why not? What is this? And he's like, he stopped communicating with me.
Thank you.
Yes. Yep, and we need to wrap it up.
Okay.
Should I do these last two?
We okay? Quick question. My son was in a federal sting operation, as you know, and received a 14-year sentence and is about 2/3 of the way through that. And I had a very educated woman say to me that when he gets out, he should not be required to register because his victim was not real, that she was made up, and that you must have, in order to be a legitimate victim, have a birth certificate and a social security number. Have you heard anything about that?
Yes, and I'm pretty sure I know who told you that.
Yeah.
But unfortunately, it's what should be versus what is. He will have to register, unfortunately, and I think that she's right, but until she gets a win on that kind of information, nobody's going to do anything about it.
Okay, thank you.
Yeah. We're done? We're done. Okay. Thank you.